Ladies and gentlemen, we present to you the 5th edition of the Ram Jethmalani Memorial Lecture Series, remembering India's legal icon. This year, India's Union Home Minister, Mr. Amit Shah, and top legal minds will weigh in on why were the 3 new criminal statutes enacted and how far do their provisions attain their intended objects. Through the course of the next 2 hours, we will hear the thoughts of Additional Solicitor General, Mr. S.V. Raju, and Senior Advocates, Mr. Amit Desai, Mr. Aman Lekhi, Ms. Aishwarya Bhati, and Mr. Mahesh Jethmalani.
Welcome to the 5th edition of the Ram Jethmalani Memorial Lecture Series. This year, with the notification of the 3 new criminal statutes, the Bharatiya Nyaya Sanhita, the Bharatiya Nyaya Suraksha Sanhita, and the Bharatiya Saksha Adhiniyam, replacing the IPC, CRPC, and the Indian Evidence Act, respectively, it was inevitable that the topic for this year's lecture would be a discussion on the 3 new criminal statutes, the need for them, and their efficacy and shortcomings. While he was one of the most versatile of lawyers, having made a mark in many branches of the law, Ram Jethmalani was first and foremost the most accomplished practitioner of criminal law. It would be the fittest tribute to him, therefore, not only to hold today's discussion under the shadow of his looming impact in a domain where he not only dominated as practitioner, but also served to craft and eke out the many nuances in substantive, procedural, and evidentiary aspects of this most challenging branch of law. Similarly, it is only fitting that today's memorial lecture, given the subject, be presided over by the Honorable Home Minister, Shri Amit Shah, who has for long envisaged a fresh look at what are essentially colonial-era laws with a view to making their provisions more apposite to an independent, sovereign state, and also incorporating technological advancement which can be used to make the dispensation of justice in the criminal sphere more expeditious and efficacious. It is the Home Ministry which has crafted the statutes provisions, introduced bills in respect each of the 3 in Parliament, steered the passage of those bills in both houses, and notified the acts so passed, along with the requisite presidential assent, on 1st July this year. While one or more of today's speakers may shed light on what they believe the drawbacks of the statutes are, the new laws have been largely welcomed for their intent and innovation. And for that, the credit must go largely to the Home Ministry, as also to all those who contributed to their drafting and to those who, during discussions, either as stakeholders or as legislators, contributed to the fine-tuning of the draft laws. There have been many seminars, lectures, panel discussions, press articles, and law journals which have analyzed and dissected the statutes. Today, in the luminous shadow of the spirit behind this law series, I have striven to constitute a panel of some of the best among practitioners of criminal law in contemporary times. 2 of them are serving law officers of the Union and will no doubt defend the new laws with all the considerable acumen at their command. Mr. Raju is already a criminal law doyen. 2 of them are eminent practitioners of criminal law at the Bombay and Delhi Bar, respectively. Shorn of the restraints of public office, you can expect a critical analysis of the laws in the only spirit which Ram Jethmalani himself knew, that of uninhibited freedom of speech. With these words, I call upon the moderator of today's event, Shri Arnab Goswami, to initiate the discussion. Thank you.
Thank you, Mr. Jethmalani, for introducing so well all our four distinguished speakers today. And ladies and gentlemen, to deliver the opening keynote address at the Ram Jethmalani Lecture Series 2024, it is my honor and privilege to introduce Honorable Home Minister Mr. Amit Shah. As we all know, he has been at the center of the consultation and drafting process for all the three new laws Mr. Jethmalani spoke about. The central government undertook a Herculean effort to undertake a widespread consultative process to prepare for the drafts of the BNS, the BNSS and the BSA. Ladies and gentlemen, to speak more on the intent and vision of reshaping India's legal system, it is my privilege to now invite Union Home Minister Mr. Amit Shah to deliver the keynote opening address at the 5th Ram Jethmalani Memorial Lecture Series. Mr. Amit Shah ji.
सबसे पहले श्री राम जेठमलानी स्मृति व्याख्यान श्रृंखला को सातत्य रूप से आयोजित करने के लिए मैं श्री महेश जेठमलानी को बहुत बहुत बधाई देता हूं, क्योंकि न केवल ये स्मृति श्रृंखला अलग अलग विषयों पर श्री राम जेठमलानी जी के एक प्रचंड व्यक्तित्व का परिचय नई पीढ़ी को कराएगी, परंतु इसके साथ साथ राम जेठमलानी जी का योगदान जो भारतीय न्यायिक पद्धति को समृद्ध करने के लिए रहा, वो कई लोगों को प्रेरणा भी देगा। मैं आयोजित इस व्याख्यान श्रृंखला को बहुत बहुत शुभकामनाएं देना चाहता हूँ। राम साहब के साथ मेरा रिश्ता व्यक्तिगत भी रहा और क्लाइंट का भी रहा। क्लाइंट के नाते मैं जरूर कहना चाहता हूँ कि संवैधानिक अधिकारों रक्षा के लिए राम जेठमलानी जी से अच्छा अधिवक्ता आपको कोई मिल ही नहीं सकता। निसंकोच मैं ये कह सकता हूँ कि ये देश के सबसे महान आपराधिक अधिवक्ता थे। इसके साथ साथ संविधान के सभी आर्टिकल, उसकी स्पिरिट्स और बारीकी से इसकी समझ, इसकी व्याख्या कर कोर्ट को कन्विंस करना, मैं मानता हूं ये राम जेठमलानी जी ही कर सकते हैं। आजादी के पहले सबसे कम आयु के वो वकील बने और 95 साल की आयु तक हमारी न्यायिक प्रणाली को समृद्ध करने के लिए कंट्रीब्यूशन देते रहे। 1976 का एडीएम जबलपुर का केस संविधान दत्त अधिकारों के रक्षा के लिए आज भी एक प्रकार से मील का पत्थर माना जाता है। 92 का इंदिरा साहनी का मंडल कमीशन केस इस देश के कई पिछड़ों के लिए इनके जीवन में नया मार्ग प्रशस्त किया है। 95 में हिंदुत्व का जजमेंट, उन्होंने हिंदुत्व को वे ऑफ लाइफ, एक जीवन पद्धति के रूप में दर्शाकर एक बहुत बड़ा उपकार इस देश की संस्कृति पर किया, जिसको सभी जजों ने सराहा भी। और 2011 का ब्लैक मनी केस जो आगे जाकर इस देश के काले धन के खिलाफ लड़ाई के नींव का पत्थर बना, वो हम सभी जानते हैं। ऐसे कई अनगिनत केसों के अंदर उन्होंने अपनी धारदार दलीलों से कोर्ट को भी असिस्ट किया और जो जजमेंट्स आए उससे हमारी न्यायिक प्रणाली को एक प्रकार से समृद्ध करने का काम किया। मित्रों, जब मैं तीनों न्याय संहिताएं बना रहा था, नए आपराधिक कानून, भारतीय नागरिक सुरक्षा संहिता और भारतीय साक्ष्य अधिनियम, तब मुझे राम साहब की कमी बहुत खली। अगर उस वक्त वो होते तो ये कानून बहुत सरलता से भी बनते और ज़्यादा उपयोगी भी बनते। आज मैं इस मौके पर राम साहब को मनपूर्वक श्रद्धांजलि देना चाहता हूं और इस फील्ड में जो नए युवा लोग आना चाहते हैं उनको मैं जरूर कहना चाहूँगा, कमिटमेंट, कंटिन्यूटी और कोर्ट को असिस्ट करने के लिए केस लड़ने की कला, ये तीनों श्री राम जेठमलानी जी से सीखना चाहिए। अपने क्लाइंट के सभी संवैधानिक अधिकारों की रक्षा करने में वो कभी नहीं झिझके। कई बार पॉलिटिकल कंट्रोवर्सियों का भी सामना करना पड़ा, तो भी उन्होंने संविधान के अधिकार जो हर नागरिक को मिले हैं इसकी रक्षा करने में कभी पीछे नहीं मुड़े। इस अवसर पर मैं राम जेठमलानी जी को श्रद्धांजलि देता हूं और महेश जी को भी बहुत बहुत शुभकामनाएं देता हूं कि इस श्रृंखला को वो लंबे समय तक चलाते रहें। धन्यवाद।
Well, thank you very much, Amit Shah ji, for your warm words about Mr. Ram Jethmalani. And as you said, so warmly, you missed his presence and his consultations during the framing of these three laws. That really sort of is something we'll all agree with. I'm sure that we all miss his presence. But thank you for your warm words about Mr. Ram Jethmalani, Amit Shah ji. And to introduce our first speaker now, over to you, Rhythm.
Arnab, our first speaker today, speaking on the theme, is the learned additional Solicitor General of India, Mr. Surya Prakash V. Raju. Mr. S.V. Raju, a very well-known face in India's top court, with him representing the union government in many important cases of our times over the last 4 years.
Thank you, Arnab. Thank you, Rhythm. I feel proud and happy, not because I'm speaking on the three laws, but because it is dedicated to Ram Jethmalani. Ram Jethmalani was by far the best lawyer practicing on the criminal side. He was also a very good lawyer on the constitutional side, but on criminal side, there was nobody to match him. And I'm happy that Mahesh Jethmalani is carrying on these memorial lectures. I wish these go on for time immemorial. And now let me begin with the topic. As far as these three laws are concerned, you know that after about 5 decades, 7 decades, 10 decades, there is always a need felt to change the laws because so much has changed. The values have changed, the necessities have changed. So the laws which were in force earlier require to be overhauled. These three laws have precisely done the same to a large extent. It is possible that they have not covered every field. It is possible that they are not exhaustive. But they are a step in the right direction. They have taken into account the necessities of the time. Let me start with the first law, which I'm going to deal with, that is the Bharatiya Nagarik Suraksha Adhiniyam, earlier known as the CRPC. This law required an overhaul in certain aspects, not on all aspects, but the overhaul was particularly with the need to see that justice is delivered in time. You all know denial of justice, delay of justice is denial of justice. So that is how this new law tries to deal with the aspect of denial of justice because of delays. So they have tried to rectify as far as possible. I'm not saying that every loophole is plugged and every delay has been plugged. That's not the case here. But delays are sought to be curtailed and delays are sought to be reduced so that justice is delivered. Now, if you look at the provisions which are made in this act, which pertain to delays and which are sought to be rectified, the first is the provision where the director and deputy director of prosecution is entrusted with a task. That task is to ensure that there is speedy and expeditious disposal of cases. So one person, depending on the nature and gravity of the offense, is put on the top to see that all those offenses which require to be disposed of early are taken care of by an officer of a high rank. That is one way in which this act deals with the delay aspect. The second is that you know that sometimes what happens is you want an urgent order from the court. You want an immediate urgent order from the court, but the court is not available or the court expresses its inability to deal with the matter. What happens then? There is no alternative judge because it has to go before a particular judge. The judge is not available. In a city like a metropolitan, you have many judges, so it goes before another judge who's holding charge. But in districts, sometimes there's only one judge. What happens? So that contingency is also taken care of by incorporating Section 8, which says if a session judge is not available, the magistrate can pass an order in emergent situations. So that is one way of seeing that matters which require urgent attention are not delayed. Another important aspect that this law takes into account is delays on account of service of summons. Many times the accused deliberately delay the proceedings, or the police are inefficient, they're overloaded with work, they can't serve summonses. So service of summons, execution of summons, issue of summons, if it is done in the old way, say by postal way or by the police officer going to the house and executing the summons, it takes time. To obviate all that, the electronic mode is now recognized and accepted as a method of serving of summons and warrants. Of course, it can't be a non-bailable warrant. It has to be a bailable warrant, which can be done in this way. Then, examination of complainant and witnesses. It can be done in the electronic way. Now, this not only prevents delays, but it is also very helpful because the poor complainant, supposing he's staying in Bombay and he wants to required to deposit in Delhi, it causes inconvenience, it causes expenditure, it is time consuming. Therefore, to avoid all that, the new code says, examine them by video, examine them by video mode. Therefore, this is another way by which the time is shortened, the delays are curtailed. The third is recording of evidence in inquiry and trials. That also is now provided that it can be done in the electronic mode. They have now also gone to the extent that appellate proceedings can also be held in an electronic mode. These are all methods devised to see that the delay, which is another facet of Article 21 of the Constitution, speedy trial is one of the requirements of Article 21 of the Constitution, is tried to be matched with because of this. Then you would see that police reports. Earlier, police reports were always in writing on papers. That has been dispensed with, and a provision has been made that police reports can be even in electronic media. It can be in a pen drive. It can be even in a hard disk, in a CD given to the court. Even copies of the accused can be given in a soft copy. And now a new provision has been made that the courts, when they take cognizance, can take cognizance on an electronic charge sheet or a police report. So this shortens the time. This is another method by which the time is shortened. One more thing that with this act does is sanction. All of you have been practicing the criminal side, all the panelists, including Amit Desai, Aman Lekhi, and Aishwarya. You all know that sanction always used to take a lot of time. Sanction, whether it is under 19 of the PC Act, that is Prevention of Corruption Act, or 197 of the IPC, always used to take time. And many a times the charge sheets used to be filed without sanction, giving rise to a lot of litigation which say, no, it's an incomplete charge sheet, therefore give us default date. All that can be obviated because now the law is that you have, if you don't reject a sanction within 120 days, it is deemed to have been granted. So deeming fiction as far as sanction is concerned is another way of reducing the delays as far as trial is concerned. Now, as far as discharge applications are concerned, there was no time limit when the discharge, when the accused could file the discharge applications. If there are a large number of accused, one accused used to file after 30 days for receiving the paper, some would file even after a year. So now the law mandates that as far as the discharge application is concerned, it has to be filed within 60 days. So probably you'll lose your right to file a discharge application if you don't file it within 60 days. So if there are a large number of accused, one after the other filing of discharge application beyond 60 days is now avoided, can't be filed. then you know that as far as judgments are concerned, many a times, many judges have faced the brunt of large number of people saying that you have reserved the judgment, you're not pronouncing the judgment. The new law says after completion of arguments in warrant tribal cases, you have to pronounce the judgment within 30 days. So that is another method or another way by which the speedy justice is delivered. In other matters, they have said 45 days from completion of the trial. That is another way of reducing the delays. Another thing that this new law says, you know that there's a provision where we file documents and ask the other side to admit the genuineness of these documents. Now people used to take time, they used to linger over it, especially the defense lawyers. And therefore now the new law says that you have to admit the genuineness of a document within 30 days. So 30 days is a time limit fixed by section 330 of this new Sanhita or the Act. Then many a times evidence was of public servants, officers, experts was being delayed because the expert who gave the opinion was either dead or not available. He was transferred, he had retired. So new law says a successor can come and depose. Therefore, you need not make out a case. You can just say he's not available, he's dead, retired, and therefore the successor can come and depose. Therefore, that also avoids a lot of delays. Then there is one thing which is something which I think they've borrowed from the NDPS Act. That is with respect to destruction of muddamal, as we call it, or material which is seized. There may be material like, say, in a case of prohibition in Gujarat where you seize liquor, it has to be destroyed. But that is required to be produced during a trial. Or say a car which is, or anything which is likely to deteriorate, or something which has, even is not likely to deteriorate, you're required to dispose it of by, and many times you make applications either in the old section 451, etc. for possession. And when the person who has been given possession of this muddamal, say loses it or destroys it, something happens and is not able to come and not able to produce it. So now the new law says, it is akin to the NDPS Act, that the magistrate can prepare sort of an inventory, take photographs, and that photograph will be admissible in evidence. So the accused can't complain that the actual material has been produced. I remember in a case where I was handling in Gujarat, the earthquake, the muddamal, the article which was seized and examined by the expert was huge columns of buildings. It's physically impossible to produce. And there were so many buildings which had collapsed, it was even difficult to identify which was the particular column. So that difficulty would be obviated, would cease to remain if this procedure is followed, which is there as far as the news CMPC or news Sanhita is concerned. Then, as far as not very small offences, but say not very grave offences like punishment with 3 years or more than 3 years and less than 7 years is concerned, they have now said that a preliminary inquiry is required to be held. In that way, for these type of offences, persons are not unnecessarily harassed because tendency to file false cases is always there, and a large number of cases which are false are filed. It is not necessary that all cases which are filed are genuine cases. So preliminary inquiry is required to be held, of course with the permission of officer above the rank of the DYSP or above the rank. But again, there they put a check saying that preliminary inquiry has to be completed within 14 days. So this would add a little as far as Lalita Kumar is concerned, that when a preliminary inquiry can be held. So 7 years, offences till 7 years, let the police be burdened with heavier offences, not these small offences where the punishment is 7 years. That is one more thing which has been added as far as the new code is concerned. Then as far as rape, examination of rape victim is concerned, there was always a delay in submission of the medical report by the medical practitioner. The new law mandates that within 7 days he has to submit the report. Now that is another thing which will also see to it that delays are reduced. Then timeline regarding supply of relevant documents to the victim and the accused. So victim is now been given a right as far as supply of documents are concerned, and apart from the accused who is otherwise entitled, that they say is 14 days from the date of appearance. Of course, now the delays are occurring because now all accused are asking for unrelied upon documents. That's different. But unrelied upon documents was never in contemplation at that particular time when this was framed. But even otherwise, I feel that as far as unrelied upon documents is concerned, whether the accused are entitled to it as a matter of right, whether they're entitled to inspection, it's all a matter of debate. There's one case which I've argued, the judgment is pending. So we'll see what happens there. So this is as far as the delay part is concerned and the speedy trial part is concerned. The case, the Sanhita, this is the Suraksha Sanhita, Nagrik Suraksha Sanhita is concerned, it also has provisions which help the accused. It has provisions which help the victim. It has provisions which help the complainant, informant. It has provisions which help the accused. Now, what are those provisions which help the accused? So it says first provision that helps the accused is in a small offense which is punishable with less than 3 years imprisonment. And if the accused is infirm or is above 60 years of age, he can't be arrested without the permission of the officer not below the rank of a DYSP. So DYSP is given more responsibility under this new act. Then it says another thing which is very important. Many times it used to happen that the person is arrested, taken away from his house. Nobody knows who arrested, from which police station they have come. So now this law mandates that whenever a person is arrested, information is required to be given to a concerned officer in the district and also to the concerned police station. And is required to keep it in electronic form and give it to the person. So you can go to the local police station and ask, so they have arrested my brother, father, somewhere, where have they taken? So you can get these details. So that helps the accused and his relatives to find out about or the whereabouts about the offense, whereabouts of where he is, and about the offense in which he is arrested. Then there is one very important provision. The law is that at the stage of cognizance, the accused is not required to be heard. You're not required to be heard till the stage of plea. Now they have made a modification. They say before cognizance, the accused can be heard. This also contributes to, supposing there's a case where the accused can throw light, the complainant has to conceal certain material facts and got a summons issued against him. But the accused at that stage comes to the court and says, look at this document, it's concealed this. If you looked at this document, no process would have been issued. So that not only gives a right to the accused, but also reduces the work of the courts, high courts. You need not go and file a quashing petition and point out to the court saying that, look here, there's an impeccable document. Now, earlier view was you can't look at documents. The new view is you can look at impeccable, and documents of sterling quality can be looked at even at the stage of quashing. The accused can produce and have a look at it. The accused is concerned, you know, that old 436A, which provided that if he's undergone 50% of the imprisonment, not for life or death cases, is entitled to bail, which is even recognized by Vijay Madallal in the PMLA cases. So if you've undergone 50% of the imprisonment, you're entitled to bail because you have undergone 50% of the case of the imprisonment, which is meant for the case, but the case is not proceeding. Now that has been reduced in case of first-time offenders. First-time offenders, it is reduced to 1/3. So that is another. Therefore, if it is a first-time offender, the law treats him differently, and rightly so. He is not a habitual offender, first-time offender. So if he is there for 1/3 of the period of time, he is entitled to. And another thing which is important, he need not make an application himself. The jail superintendent is supposed to make an application saying that, look here, his imprisonment is 3 years. He's undergone one year. He's a first-time offender. He intimates it to the court, and the court will decide on the application or the information given by the jail superintendent. These are some of the features which help the accused. Now, as far as witnesses are concerned, Section 398 provides for a witness protection scheme. It's a very important thing. Of course, a little more work is required to be done, but the law now has provided that there can be a witness protection scheme like you have in the US, where the identity of an important witness can be changed. He can be given a new identity, placed at a place where if some gangster or some terrorist is after him, nobody knows where he is. So whether it is successful or not, whether there are loopholes, whether there are more, that's a different thing. But the law has provided a contingency or a case where witnesses who apprehend that they will be killed, they will be threatened, their family will be threatened, are protected. In this way, what happens is that witnesses who are afraid will come forth, will be no longer afraid if the law protects them, and they would freely and voluntarily give evidence. Then there are certain new provisions which are there. One is handcuffing. How far that provision will hold the field, whether it is unconstitutional or not, will have to be tested. Because judgments on handcuffing, there are some judgments on the handcuffing, whether it violates those judgments is another issue. But it's not that in every case the accused is to be handcuffed and taken to the court. You know that there is a problem here. The courts say you can't handcuff. Many accused have taken advantage of this and escaped while they were being produced to the court. From the police van to the court, there are many instances. And I know of a few instances where the person just went to the bathroom from the window, he jumped and ran away. That's another. But even where the handcuffing is concerned, when you try to enter a lift or some place where there is a lot of rush, so therefore you have to strike a balance between handcuffing and escaping of prisoners. So their sort of balance is sought to be struck. Then another thing that this law does is the old 167 with the new 187. Many a times the earlier law mandated, which has now been doubted in Senthil Balaji, whether the 15 days remand has to be the first 15 days or not. Or it can be anywhere between the first 60 days or 90 days as the case may be. But the new law rectifies this problem. And this required a rectification. You can't, supposing the police want an accused at a later stage where they get new material in the same case, and they want the custodial interrogation, it's not permitted because of CBI versus Anupam Kulkarni. It says first 15 days. There's no logic accepting that the literal interpretation of the law. The law, if you really want to render justice, should be that when you require an accused, the police remand should be granted. Not because in the first 15 days, even if the requirement is after 16th day, you don't get a custody. That would result in injustice because you may sometimes require a custody of an accused after 15 days. So the new law says it is 60 days, the period of remand for the default bail, that is 7 years, etc. You get it for 40 days. Within 40 days, you can ask for that 15 days period will be anywhere between those 40 days. And in the other case, it will be anywhere between those 60 days. So this is a welcome provision. The lawyers for the accused may not agree. But in order to find out the culprit, get evidence, this provision was necessary. Then there is another provision which was there. That provision is regarding house arrest. Can a person be put under house arrest? Of course, constitutional courts have been doing it because there are no fetters on constitutional powers of the court. But as far as the magistrate is concerned, as far as session judge is concerned, can you say that I'm remanding you to judicial custody? Police custody, there's no question of home stay or home arrest. But judicial custody, can it be home arrest? In Navlakha's case, the Supreme Court granted home arrest. But that is because the Supreme Court is Supreme Court. It is not bound by the ordinary criminal law. But the issue still was whether a person can be put behind the bars in his own house, and that would amount to judicial custody. That has set at rest because they have now said that the only place where the person can be detained is a person, is a place where it has been declared to be a prison by the government. So unless a house is declared to be a prison, you can't be put under house arrest. That is another good feature, because otherwise rich and affluent people would say, give me house arrest. When to put a person in house arrest is another issue. Now, another important thing which is in consonance with the Supreme Court judgment is a voice sample. Earlier, there was a dispute whether an accused can be compelled to give his voice sample, whether it would be hit by Article 20, sub-Article 3, whether it would be self-incriminating. That has been put to rest by the Supreme Court, that even a voice sample can be taken, just like a blood sample or a fingerprint or a handwriting. That has now been incorporated in the CRPC. A magistrate can order the taking of voice sample, also apart from handwriting, fingerprints, etc. Another thing is, for this purpose, there is no need to arrest the accused. So that is something in favor of the accused. There's one more thing that the new Act does. It protects the public servants in the real sense. Under the old laws, a public servant was protected only after it reaches the stage of cognizance. If a public servant has done something in the discharge of his duties, why should he face investigation? Why should he face arrest and wait for sanction till the cognizance? Of course, there is now 17A also in the PC Act, but that is only with respect to PC Act offences. So what does the new law say? The new law says that even for ordering investigation under the old 156(3), which is now 175(4), if it is against a public servant, you require a report from a superior officer. And if the public servant concerned is also required to be heard. So no cognizance without the public servant. Then no 156(3), no police investigation. Sorry. Now even at the stage of cognizance, which is old 200, now 223(2), they said same thing. They said, if you want to take cognizance against a police of a public servant, you can't do it without hearing him, without giving him an opportunity, and without asking and getting a report from a superior officer. So public servants are also now protected in a way they should be protected, not superficially, because till the cognizance is taken, we don't treat you as public servants who have done something in the discharge of duties, but only after cognizance you are treated separately, no trial. But what about arrest? What about other things? What about investigation? That is also taken care of now. Now, they also applied the judgment of Siddharth. You know, earlier, 170 of the CRPC, where several magistrates were not taking the charge sheet unless the accused is brought in custody before them. Siddharth, that is 2021 Supreme Court online 615 has taken care of it. That thing which Justice Kaul had said in Siddharth's case has now been taken care of in section 190, which says you need not produce an accused along with the charge sheet. He is not to be taken into custody for producing the charge sheet. Then limitation also they've taken care of in this sense. See, if you look at the law of limitation, old 468, now 514, it says no court shall take cognizance. Now the issue was, is it supposing the offence has taken place, say, 3 years back, and the police after investigation files it, complaint after, say, although the FIR is registered on the day of the offence, the police files a charge sheet after, say, 5 years. And on the date of cognizance, it is time barred. So now they have taken a very practical view and said, no, it is not the date on which the cognizance is taken that the limitations will be computed. It is the date on which you file an FIR or date on which you file a complaint, and not the date of cognizance. That is also a very good thing that they have done, because the person was not inactive. He has moved the law enforcing agencies at the right time, in the nick of time, and he should not be penalized for any delays caused by the investigating agencies. Sometimes you go and file a complaint, the magistrate says fixed for hearing, and the magistrate is transferred. It doesn't take place for years, and the file is lost. And after 3 years, it surfaces, and they say, no, now it is time barred because the date of cognizance is time barred. So that injustice has also been cured by this new law. Then victim and informant have been given also certain rights. The first right that the victim has been given is that he has to be informed within 90 days of the progress in investigation. Victim also is part of the justice delivery system. Justice has not only to be delivered to the accused, but it has also to be delivered to a victim. Victim must know, I have filed a case. What has happened to the case? Let me know about it. So a right to be informed about what happens to his case is also given by law, which is mandatory as far as the police is concerned. Sometimes what happens, prosecution is withdrawn without the victim knowing what happened, what is happening to my case. So now 321, which is the new 360, they say victim has to be informed and he has to be heard before prosecution is withdrawn. So victims' rights are also protected in a way. Now, one good thing about the last good thing, because I don't know.
Yes.
One, I don't know whether I have overshot my time.
No, yes.
But one last thing is this. This is a novel thing, that is community service as a mode of punishment. You have cases where the courts have given community service as a mode of punishment, but it was not a statutorily recognized mode. Constitutional courts have done it. The magistrate could not have done it. The moment the magistrate would have done it, a complainant represented by one of eminent lawyers as Amit Desai or anybody would say, there's no authority. How could you should have sent him to jail? Why is he giving community service? Therefore, this is now statutorily recognized that in petty offences, not exactly petty offences, but borderline petty offences also, community service has been provided. In US and UK, they already had community service as a mode of punishment. So this is a good method of punishment, taking into consideration the modern requirements of law. Now, as far as the Bharatiya Nyaya Samhita is concerned, that the IPC, I just want to say a few things. Just give me a minute. So much that it's difficult to. One thing is that it recognizes gender, recognizes trans. So it is not only male or female, transgender is also recognized.
That's true.
Definition of child has changed. Then a new section is, there's always an issue. Many courts have held this way, other courts have held the way. Whether a promise to marry, if you have, say, physical relations with a girl, giving a promise that you will marry her and you don't fulfill the promise. Earlier, they used to file a case of cheating. Cheating, the court said, no, your intention at the inception was something else, therefore it may not amount to cheating. Now it has been specifically made an offence under Section 69.
Yes.
That is one thing. Then rape of a woman below 18 years, the life has been interpreted to be a remainder of the natural life.
Yes, sir.
Lynching, now these are all provisions which have been discussed, where lynching has been made an affair. The negligent driving, if you run away from this vehicle, I think I've taken a lot of time. I think I even otherwise have to go. I'm so sorry, but may I be excused.
Our next speaker, without any further ado, we'd like to introduce Mr. Amit Desai. Thank you very much, Mr. S.V. Raju, for your comments there. Thank you very much. And our next speaker is Mr. Amit Desai.
Absolutely.
Rhythm.
And he is the senior advocate in the Supreme Court, Mr. Amit Desai. Mr. Desai, a third-generation lawyer walking into the footsteps of his famous father, late Shri Krishnakant Desai. He's also, Mr. Desai himself has worked in close proximity with stalwarts of the Indian jurisprudence.
Mr. Mahesh Jethmalani, Swami, my dear friends and colleagues at the bar, and the audience of laymen, intellectuals, and lawyers. Mahesh, thank you for giving me the privilege to speak on the momentous occasion of the 101st birth centenary of the Bhishma Pitama of criminal law in India. This occasion is made even more significant as in this 75th year of our independence, we now have the reenacted 3 criminal laws effective from July 2024. But before sharing my thoughts on these 3 laws, I wish to say a few words about Ram Jethmalani. Ram would have been 101 years old today. Ram was a household name to me since my late father, Krishnakant Desai, a senior advocate, was a close contemporary of Ram in Mumbai. The 3 brilliant minds at the criminal law bar in Mumbai from the 1950s to the 1990s were Ram, Krishnakant Desai, and Feroz Vakil. And those were the times when trials were conducted daily and the trial courtroom was a vibrant battlefield. Ram, a prodigious student born in 1923 between the 2 world wars, entered the legal profession in a tumultuous era of the freedom struggle. Having been born in Sindh in Pakistan, he experienced the pain of the partition of India and Pakistan. He also witnessed the drafting of the Indian Constitution and the birth of the Supreme Court of India. The cataclysmic events of the first half of the 20th century surely shaped Ram's liberal thinking. Ram's dharma and karma were preordained. The rule of law ran through every vein in his body, and he used his intrinsic knowledge of law and history to achieve political status and influence political outcomes, some of which were mentioned by the Honorable Home Minister. His liberal thinking, his unwavering commitment to protect liberty in its broadest sense, and his deep sense of justice for all brought Ram, once a penniless lawyer, into the thicket of criminal law, a law both used and misused during our freedom struggle. India's fight for freedom was at a critical juncture. Between the 2 world wars, with the then recent introduction of the criminal law triumvirate, which was the Indian Penal Code of 1860, the Criminal Procedure Code of 1898, and the Indian Evidence Act of 1872, the Indian courts were flooded with cases of sedition and conspiracy aimed at overthrowing the British rule. Some of the most memorable sedition cases were those of Bal Gangadhar Tilak and Mohandas Karamchand Gandhi. The conspiracy cases that captured the public's imagination included the Meerut conspiracy case, Dhaka conspiracy, Muzaffarpur conspiracy, and many more. And you will realize why I'm giving you context of this. Ram's birth, a few years after the Rowlatt Act of 1919, which was introduced to curb the growing nationalist movement by giving police the power to arrest without reason and detain without trial, and the events that followed, including leading to Gandhiji's rise to prominence, must have shaped Ram's destiny to enter the world of criminal courts. Ram's legal and political career has been spoken of and written about extensively over the years. Today, Ram lives on as an idea, the idea that is Ram Jethmalani. What is this idea? What is this idea of Ram? It's an idea that embodies fearlessness, personal liberty, free speech, innovation, the rule of law, equality, pro bono service, and justice. But the question we have today is, have these ideas found their place in the new laws? Let's first talk about liberty. In recent years, there's a public perception that the criminal justice system has shifted from punishment by conviction to punishment by arrest and custody. The Supreme Court has been struggling to balance liberty rights. But has the BNSS addressed these evolving issues regarding the powers of arrest, remand, and bail adequately? The BNSS, Section 47, does not clarify the requirement that the grounds of arrest must be communicated in writing at the time of arrest. The BNSS, Section 187, modifies the provisions of remand, but does not provide that the magistrate's first duty is to ensure that all constitutional and statutory obligations are fulfilled before the accused is produced. And if those duties are not met, the accused should be immediately released. These principles having been established by the Supreme Court in Anesh Kumar and more recently reaffirmed in Satinder Until. Another concerning change is in regard to police remand. My learned friend, Mr. Raju, just talked about it. The period of police remand initially was limited only to 15 days at the first stage of production of the accused before the magistrate. It is now any 15 days within the initial 40 or 60 days, depending on the punishment for the offense. This reverses the judgment in Anupam Kulkarni, where Ram successfully limited police remand to the first 15 days after arrest. But why is this remand restricted? My learned friend, Mr. Raju, had something to say about it. The 15-day period was always intended to protect the accused from methods which will be adopted by some overzealous and unscrupulous police officers. This modification in the new law may lead to the abuse of the process by such overzealous and unscrupulous officers, as courts of first instance could extend remands to at least 40 to 60 days as a matter of practice, allowing the police to manipulate and prevent early release by seeking intermittent custody. Mr. Raju made a comment to say that, well, the accused can be summoned at any time by the police, and that's the reason why there is a need for this extension. But that is never the principle of law that was ever established while protecting liberty of accused. We are not intended to be in a police state. However, this new chapter, these new changes appears to shift the protective approach of the courts in the past. They threaten the Supreme Court's consistent message to courts of first instance to follow the rule of law, that is bail, not jail. The new definition of custody in the BNSS also raises concerns. Custody under the remand provision is now defined as custody in a police station or prison. So time spent outside a police station for investigation, examples are during recovery of evidence, or time spent in a hospital, or time spent on a custody parole, or under house arrest, or otherwise outside a prison, does not count as custody within the meaning of this provision. This negates the Supreme Court's efforts to liberate accused from the weaponization of custody and impacts the calculation of the number of days in relation to the right to default bail under this section. And I think everybody understands the intent of that. The Supreme Court's recognition of house arrest, as in the Gautam Navaka case, a great progression that was made by the Supreme Court, may no longer be feasible. For these seemingly minor changes, if Ram was here, his booming voice would have said, these changes remind me of the police powers of pre-independence India. They turn back the clock on our efforts to gain independence and undermine the Supreme Court's efforts to protect personal liberty rights. In 2006, following years of strictures by the Supreme Court, incarcerated accused awaiting trial found relief through Section 436A of the Code, which Mr. Raju just adverted to, which introduced a distinct default bail right alongside the original right under 167 of the erstwhile Code. However, in the new provision, under Section 479 of the BNSS, this right has been significantly restricted. Offenses punishable by life imprisonment are now excluded from this particular provision. And now there are 60 such offenses which are punishable with life imprisonment. Moreover, if investigations are ongoing in more than one offense for the same accused, this right is excluded regardless of the quantum of punishment. Given our overcrowded prisons, with a total inmate count in excess of 5,73,000 and an overcapacity of 131%, these provisions need some urgent reconsideration. I believe liberty has been compromised in our journey towards a better society. This brings me to another aspect of the legislations. This is punishment and commutation. The offenses punishable by the death penalty have increased by 20%, and life imprisonment for the entire natural life has increased by nearly 50%. We seem to be moving towards the retributive form of punishment instead of being reformative. The Supreme Court has, over the years, been reducing the number of cases in which death penalty is imposed. The ever-escalating debate of reformation under the Article 21 Doctrine of Liberty and its compatibility with death penalty resulted in the death penalty being imposed only in the rarest of rare cases, and only when the alternative option of life imprisonment was unquestionably foreclosed. However, we have 20% more offenses awarding the death penalty. The offense of imprisonment for life, that is rest of the natural life of a person, is another form of meting out effectively the death penalty, since there is no remission for this punishment. Once the court passes a sentence for the entire natural life, it has effectively condemned the prisoner to the death penalty. It takes away any hope of release for good behavior, repentance, rehabilitation, reformation, age, health, etc. And by increasing the number of sections to which these egregious forms of punishment is made applicable, we are widening the net instead of the reformist direction of the Supreme Court in not awarding these punishments except in extremely rare situations. Commutation. The philosophy of commutation is grounded in the belief that public welfare will be better served by inflicting less than what the judgment fixed, recognizing the value of mercy in governance. Every civilized country recognizes this and has therefore provided for such power to be exercised as an act of grace and humanity in proper cases. Without such a power of clemency, a country would be most imperfect and deficient in its political morality. The 1973 Code allowed a broad discretion to commute any sentence to any lesser sentence so that you can reduce a life imprisonment to even a shorter term or even to fine. But the new legislation, the BNSS, restricts this discretion. It introduces what I call a staircase system, allowing only a one-step down commutation, that is from death penalty to life imprisonment and no further, or from life imprisonment to no less than 7 years, and so on and so forth as provided in the section. This restrictive approach takes away the discretion of the state to show its mercy, grace, or humanity in a given case. Let's take another aspect of this legislation. One of the other concepts introduced by the BNSS, which potentially takes away liberty, is the ability to conduct a trial and render a conviction against an accused and sentence him in absentia. Previously, the code only provided for trials in absentia to protect the evidence of various witnesses until the accused was found and brought before the court. Now, Section 356 provides for a complete trial, a judgment of conviction, including the imposition of punishment in the absence of an accused. This raises significant due process concerns. To obviate the obvious natural justice issues, it provides for a legal aid lawyer to such an accused. But in a criminal trial, where witnesses must be cross-examined, it is impossible for a lawyer to represent the accused without any communications with him or instructions from the client. Sexual offenses and rape. The offense of rape continues to resonate deeply within India's consciousness. Each time a case shakes public awareness, laws have been amended to increase punishment, whether in 1983, 2013, 2018, and now in 2024. However, the Ajmer case, the Delhi case, and now the Calcutta case are all reminders of the fact that the inadequacies lie not in punishment, but in investigation and the speed of trial. So have we strengthened these processes sufficiently? The BNSS attempts to address this by increasing the number of doctors who can conduct medical examination and also setting deadlines for the reports of such medical examination, Mr. Raju mentioned. Though the BNS, the Nyaya Sanhita, like the Nagrik Suraksha Sanhita, like the Criminal Procedure Code, provides for deadlines to complete such investigations and trials, but it ought to have provided for administrative and penal liability for not completing them in time. Introducing administrative or penal action for law enforcement officers or administrative action for judicial officials who fail to complete proceedings within the prescribed time frame would have indeed helped ensure greater accountability, and that is the need of the hour, as we all understand. Let's now talk about gender-neutral laws. As Indian courts have evolved to protect the LGBTQ plus community, there was a pressing need for gender-neutral sexual offense laws. However, when it came to drafting the sexual offences laws, the BNS missed the opportunity. Offences are still gendered. An offender of a sexual offense can only be a man and the victim a woman. Section 377, which everybody would be familiar with, which protected members of the same sex from sexual assault and which penalized bestiality, has not been reenacted. Today, the LGBTQ plus community is at risk inasmuch as sexual assault against partners is not a crime. Even as of June of this year, we read of Suraj Revanna, the MLC from Karnataka, being charged with sexually assaulting a male party worker, which clearly indicates a need to keep the offense on the statute book. Courts have also recently recognized its lapse and expressed the need to urgently amend the law. The BNSS, for the first time, has recognized transgender persons as a distinct gender. However, the transgenders are at as much risk of sexual offenses as anyone else. But they are not included in these offenses as victims or as accused, and today, any sexual assault on them is not a crime. Terrorism and organized crime. Both are now in the BNS. The offenses are bodily lifted from the UAPA and the MACOCA with minor tweaks. Terrorism in the BNS includes economic security, but this term is not defined. Without a definition, considering the width of the phrase, any form of financial activity could, at the whim of a police officer, be categorized as financial terrorism and be included within economic security. So, could the recent Hindenburg shorting of shares on the Indian Stock Exchange, leading to loss of about $100 billion in the market value, constitute economic terrorism? Another new offense is the offense of organized crime. Although its body lifted from the MACOCA, the BNS has made an addition. It includes economic offenses within the definition of organized crime. Economic offenses have been defined in the section to include the like of criminal breach of trust, forgery, or defrauding a bank or a financial institution for obtaining monetary benefit. So what was always a violent crime now includes the passivity of a commercial fraud. Business community and investors need to be cautioned. Bringing terrorism and organized crime under the BNS, and whose investigations and trials are now governed by the BNSS, these heinous crimes against the sovereignty and integrity of the nation have been tempered. There are no twin conditions for bail. There's no provision for extending remand beyond 90 days. There are no specific procedures for call interceptions. And there's no admissibility of co-accused statements recorded by senior designated police officers. Also, there is no protection to a victimized accused since there's no provision for sanction to investigate or prosecute. Investigations are now by local police officers and not by specialized officers of the NIA or the CBI. This change probably believes that terrorism and organized crime activities as threats to nation are waning and are no longer in need of specialized provisions and agencies. I do hope it is so. There's an interesting offense called of attempt to suicide, which has now been introduced. BNS also creates a new offense of attempt to commit suicide. The offense has the mens rea to compel or restrain a public servant from discharging his official duty. Political dissent through hunger strikes have been used throughout our history, be it the hunger strikes of Gandhiji against the British, or Anna Hazare during the India Against Corruption movement, or against the Haryana government to release water. All of these could now be brought under this section. Before concluding, a quick comment on the Bharatiya Sakshya Adhiniyam, which is a statute which has been altered the least. The significant update is a broadened definition of what constitutes a document. Though there isn't much change in the statute itself, there will be significant issues of how we are going to prove relevant and admissible evidence, given our lives are substantially being lived in the digital world of deepfakes, hacking, and digital fabrications. Much can be said of these three laws, favorable and unfavorable. These legislations will keep the criminal law bar preoccupied for years to come. But if Ram was in our midst today, I'm sure he would have said, and I would like to quote, "The biggest enemy of the criminal justice system is not the criminal. It is the apathy of the people running it." Close. To ensure that the new laws reflect Ram's idea of liberty and equality, we must remain vigilant in our pursuit of justice. Well, thank you once again, Mahesh, and the entire team for this opportunity that you've given me on this occasion.
Well, I think there, as he said, there is much that is to be said in favor of the law, and there is much that is missing in the law, and there's much, to sum it up what he says, there's much that is capable of misuse. But, let me tell you one thing, that let's take the case of, this increasing tendency towards enhanced punishments. To some extent, the fact that you have the death sentence, right? I mean, most of us are reluctant to have death sentences for any offense, right? It should be used in the rarest of rarest cases. In practice, that is the test which the courts have already applied. You may have as many statutes. Many statutes that and by the way, these are not mandatory. These are all in the alternative, and the alternative is to be exercised in the rarest of rare cases. I can see why legislatures and governments impose, the death sentence. It is to some extent retributive, but it is more because it is supposed to be a deterrent. Even the fact that it's on the deterrence aspect doesn't really help, because you've seen even after Nirbhaya, people have not been deterred by gang rapes to indulge in gang rapes. But that doesn't mean you don't keep that deterrent effect on the statute books. In practice, right? It is rarely, if you count the number of people on whom the death sentence has been inflicted, where it is an optional sentence, it is really the rarest of rare cases. The only cases in which, for instance, it normally is used, and it is swiftly used, and that is a necessity, is in cases of terrorism where you threaten the very integrity it is wanton killing. It is wanton killing. It is killing. And the death sentence is required because you know what happened in IC 1814. You kept people in custody, right? And you got a hostage exchange crisis. That's the only case where the death sentence should be inflicted, and as a matter of fact is inflicted, and it should be inflicted expeditiously. Now, as far as his arguments on bail are concerned, unexceptionable. Many years ago, my father tried to put in a 3 adjournment rule in the Civil Procedure Code. And it was the bar. It was the Indian bar. I mean, I'm not saying Amit is one of them who objected, but it was the Indian bar, and he almost lost his law ministership because he dared to venture in that area. There's a vested interest. There's a vested interest in the bar to delay matters. And it's happening at all levels, let me tell you.
Yes.
It is unfortunate. And no matter what kind of timelines you put for trials, and there are no timelines for trials, and probably there's another reason, a more plausible reason, and that is because how do you put a timeline? In some cases, you have witnesses running into hundreds and even thousands. Where do you draw the line? You can't. It all depends. It depends on the number of witnesses the case requires, or the prosecution deems it requires. It then requires absence of prolix cross-examination, right? Which is really the duty of the trial judge. So this can't be statutorily imposed.
No,
so much of dispensing justice, both at the investigating stage and the trial depends on the good and common sense of a judge. Senthil Balaji, where Raju came out in defense of it, and therefore you might require a second remand. Because it's happening. Crime is becoming more complex, it's becoming more cross-border. And it's becoming even more difficult for you to unearth evidence in the first 15 days. This is a prosecutor's nightmare. So it is, in many cases, you do discover evidence at a later stage when you make further arrests and so on and so forth. Now, I'm not canvassing for anything, but let me tell you one thing, that this extension of police remand, not in the first 15 days, and I'm very conscious the other day, I was delivering a speech and Justice Lalit had a dig at me saying Anupam Kulkarni, who was my co-panelist there, was actually argued by Ram Jethmalani. Yes, it was, but it was in a case where crimes were much less complex. It is much more difficult. I mean, you have cybercrime. Amit has written an article on it, a very good article in the Indian Express, which I would recommend, that crime has become infinitely more, in its execution, complex. So, Senthil Balaji already had overturned Anupam Kulkarni by saying it can be any time between the 15 days and the 90 days. Senthil Balaji actually referred Anupam Kulkarni to a larger bench for reconsideration.
Yes. Now,
What this has done is it struck a medium. It says that you can arrest people, but only during the first 40 periods. In the case of 60-day offence is punishable, and, and 60 days where the offence is punishable with 90 days. Now, I have a problem even with that because the Act uses the word, just to tell you that I have a problem with what is the phraseology. What is the problem with the phraseology is it says in parts, that you can be arrested in parts, remanded to police custody in parts. Now, I would have restricted that only to 2 parts. Amit and Aman and Aishwarya, please note. I would have said 2 parts at the most. Right now, the language of the statute says, because you can even remand a person for 1 day, the language of the statute almost permits you to do it 15 times for 1 day each.
Absolutely. Thank you, Mr. Desai, for that invigorating response that you had given. I also want to right now, Mr. Jethmalani, introduce our next speaker, Aishwarya Bhati, Additional Solicitor General.
Yes.
Presently, she's been a distinguished member of the bar for over 2 decades and is the youngest woman advocate to be designated as a senior advocate.
Thank you very much for such lovely words, Arnab and Rhythm. It's actually an honor and a privilege for me to be here. I'm very grateful that Mahesh Jethmalani sir reached out to me and told me. I didn't know that the format was going to be such a spectacular format where I'll get to learn much more than what I get to share. But it is absolutely an honor. I was a very young lawyer when Mr. Ram Jethmalani was at the helm of, as a doyen of the bar, as the Bhishma Pitama. And one thing that I definitely have imbibed with me in my journey of over 2 decades is him saying that, you know, characterizing the step ladder approach that a lawyer must always bear in mind, that lose your brief, but don't lose the client. Lose the client, but don't lose the judge. And lose the judge, finally, lose the judge, but never lose your conscience. So that really epitomizes what Ram Jethmalani sir used to believe in, and as young lawyers, what we imbibed in. Now, on the aspect of the 3 laws, adding to what has already been said, I think I want to take the perspective, and before I do that, I also wanted to tell Rhythm that I'm no longer, happily, no longer one of the youngest women lawyers to be designated. There is a barrage of younger women lawyers that have been designated by Supreme Court, very distinguished colleagues and friends of mine, and I am extremely proud of their journeys. And this is the sign of changing times. Now on to the 3 laws. I made a few points, and I do want to start with how I see this as a journey of our nation from being ruled to being governed. Being ruled as a colony to being governed by our own as a democracy, of the people, by the people, and for the people. Now, what is it that is expected from criminal justice system, the criminal laws of the country? What is it that the citizen expects from the criminal laws? Let's bring the citizen in the center of this all. I think the very effective and impactful changes that the new laws have done. Number 1 is integration of technology, making it efficient, time-bound, forensics as mandatory for all offenses which are punishable for more than 7 years, digital technology, information technology as a force multiplier. Now, we've all have been using technology on our personal levels for a few decades now. In fact, if you see the changing face of the courts, you will not recognize it if you are coming to a court after, say, 7-8 years. The face of courts have changed completely. They are very well empowered digital platforms that are available, giving access to justice to ordinary citizens. Now, integrating technology into our criminal justice system to such an extent where it is not just common individuals who are using the technology, but the criminal justice system is using the technology, reduces the burden of witnesses that can go hostile, witnesses that can be empowered, witnesses that can subsequently be tampered with, because scientific evidence will not lie. And integrating technology and scientific evidence and forensics into criminal justice system is a huge leap in my respectful submission. Now, one more thing that I find very interesting and impactful, it has been observed, and it has been rightly observed, that it is not the gravity of the punishment that deters a criminal. It is the certainty of the punishment that will deter a criminal. Now, how the punishment aspect has been made certain, firm, yet humane in bail and punishment both. From my perspective, now Section 436 is something that Raju sir and Desai sir both spoke about, Section 436A, which now is 479. And I want to share this one anecdote. Recently, the Honorable Supreme Court was considering whether the implication of Section 479, which now includes a very reformative step, because for first-time offenders who are accused of offenses which are less than 7 years, they are entitled to bail just on 1/3 of the punishment. The previous incarnation of 436A was 1/2 of the punishment. Now, 1/3 of the punishment for small offenses less than 7 years and first-time offenders, and that too, no application is required. It is on the recommendation of the prison superintendent itself. That is a very, very reformative step in bringing our jails into a little bit of better management and overcrowding. Now, the Supreme Court asked us as union government, I had the privilege of appearing for the union government in that, and the Supreme Court asked us whether this will apply from the offenses that have taken place from 1st July 2024 onwards, because that is when the acts have come into play. We took instructions, we went back to the court, and we informed the court, said that since this is the procedural reformative part of the criminal justice system, of the criminal laws, then this should give benefit, and it is our view that this will give benefit to anyone who has been in incarceration from 1st July 2024 onwards. So anyone who has undergone 1/3 of the punishment and is a first-time offender, falls in that bracket, is entitled to the benefit of 479. Now, the aspect of punishment, we have already seen the community service aspect of it. You know, a lot has been said that it is old wine in new bottle, not much has been changed. But I want to bring one perspective into the focal point here. Societies evolve over hundreds of years, decades. While it is important for societies to embrace changes that impact our societies in technology, etc., the aspect of crime, it is not everything that the society considers immoral, antisocial has to come into crime. It has this journey of civilization has taken several decades and centuries for crimes to be understood in gravity in different forms. So to expect that changes would happen to criminal justice system or criminal laws in a manner that would be completely overhauling the criminal laws or redefining offenses or redefining punishments would have been actually unfair. The impact has to be seen from how the citizen is to be impacted by the criminal justice system, by the criminal laws. And therefore, the yardstick of our adversarial system, India has a system, our criminal justice system follows an adversarial system where every crime has to be established beyond the shadow of reasonable doubt. That system has not been tampered with in any manner. The crime has to be proved beyond the shadow of reasonable doubt. But today, you can use technology, you are mandated to use technology, forensics, information technology for enhancing the certainty of law to the accused person, and also bringing victim into the forefront again. I think it is imperative for us to appreciate that the role and the focal point of criminal laws has to be with regard to how the victims are meted out by the system and how witnesses are protected. So to bring in these two aspects, the witness protection system to be notified by all states in consultation with the union government, and victim compensation schemes to be formulated by all states, again in consultation. These are very progressive steps which are going to impact the citizens who unfortunately have an interface with the criminal justice system as victims, as witnesses. And the mandate of time has been prescribed. And I am skeptical as to whether it was going to be followed in true letter and spirit. A system, any good system, will always be as strong as its weakest link, probably, and will always be dependent on the person who's on the chair dispensing justice. But these statutory changes reflect the aspirations of our nation. I want to bring special focus on offenses which are against women and children. I think it is very important, very important for us to note as a nation that our focus has been on offenses against women. And despite the best of our efforts, the nation has not gotten out of the clutches of the offenses against women. And that is impacting one half of our women population, really contributing to nation building. So bringing all the offenses against women in one chapter, as against segregated across 4 chapters, bringing in all the best practices that have been evolved. I think that is one aspect that we have missed to fully appreciate, that the recommendations of all the commissions, including the Nirbhaya recommendations, etc., all have been kept intact, included in the new law. The aspect of that, the changes that were made by judgments, for example, the judgment of independent thought, which eliminated the distinction between a child who was married. So a sexual offense, rape with a woman who was a wife and below 18 years of age, between 16 and 18 years of age, was something that was permissible under the previous penal law. Independent thought Supreme Court judgment did away with that distinction and said child is a child. And that is something that has been brought into the system. Now, Section 377 is something that Desai sir mentioned. And I personally also feel that what was decriminalized by the Supreme Court in Section 377 was only a relationship between 2 consenting adults. And therefore, the law will have to make some amends with regard to relationships which are not between consenting adults and which do not fall within the aspect of offenses against women, which are already described amply in the system. But I do differ with Desai sir on this aspect that we should have made a leap forward and made these gender neutral. I mean, it's all very idealistic to say that India should have kept pace and we should have made it gender neutral. But how many countries in the world have really made it gender neutral? How many countries there are gender neutral rape laws? Are we really ready for it? The purpose and essence of law is to curb a mischief for the maximum. The law is never made for individualistic persons or for exceptions. Law is always made for the masses. It is the Hayden's rule of mischief, which is what weighs with the legislature when a law is framed. And I mean, maybe it is a little odd to say, but I think the country will be ready to have gender neutral laws when we have equal number of perpetrators of sexual offenses as women or people from other genders. I don't think we are ready. These are steps that the society will have to take incrementally. We can't jump on it. A little was said on deceitful promise to marry. It was already, this is a provision that has already been interpreted sufficiently by Supreme Court. And the section has been included to really protect women who are falling victim to the deceitful ways where promised to marry. And it should not be a simple cheating or a forgery that a person should be left with. I can see that the time is running out, so I'm just going to focus on a few things. There's one example I want to say. I mean, a little was said on trial in absentia, punishment and sentencing in absentia. Just last month, I had a file that came on my table where the trial court record was lying with Supreme Court on a pending appeal, and the requisition had been sent from the trial court for that record to be sent back so the next trial could continue. When we opened the file, we realized that what was being requisitioned was the trial court record of the 1992 Mumbai blasts. That is something that the nation can never forget. But what I found really, I mean, it was really, I was aghast to note that there is a third trial that now needs to be held for people who were absconding, accused who were absconding, who committed this heinous terrorist action on our nation. One trial had already happened that came up to Supreme Court, attained finality. Second trial had happened, that was pending before Supreme Court, and now the third trial has to take place for accused who have been absconded subsequently, who have been apprehended subsequently, and now the trial court is asking for that record. Why should these people who don't even want to come before, who don't want to come before the court of law of the system in the country, why should they be given any benefit if they don't want to come before the court of law in the country, to come before the laws of the country, the constitution of the country, the criminal justice system of the country? Then they deserve to be tried and sentenced in absentia. This also includes the aspect of abatement from outside India. That is a specific offense that has also been added. To my mind, this is going to go a long way for the handlers who sit across the borders and find people who are carriers or who are just people who execute the offenses which are against the sovereignty of the country. Having said that, I do want to say that I feel that these offenses which are against the integrity and sovereignty of the country need to continue to be dealt with specific laws with the full force of the law and not the ordinary penal law. But the act the laws do provide for an assessment to be made by the officers of superior designations. So then sensitivity and inclusion in language is something I do want to mention. Attempt to suicide as a protest was mentioned, but attempt to suicide removed from the penal statute and treated as a mental health issue shows the sensitivity of the statute. So I think I'll just sum up. There are a few points that are remaining, but I think I need to leave enough time for Lekhi sir also. So I'm just going to sum up by saying that please look at it from the perspective to help him. It should not be the onus on the state and officers or public prosecutors to be standing up for the victims, and it should be the victim centricity of justice orientation and victim centricity of the criminal laws that should prevail. Of course, the laws will be ironed out as they come into practice, but these were some of my experiences and my insights on these three laws. Thank you very much for this privilege. Thank you.
Next distinguished senior advocate of the Supreme Court of India, Mr. Aman Lekhi, to now speak. Mr. Lekhi, who was formerly served as an additional Solicitor General in the Supreme Court, very well known for his expertise in constitutional, criminal and public law.
This topic is of momentous importance. I'm thankful to my dear friend Mahesh, an outstanding lawyer and parliamentarian, for this privilege. I'm bringing up the rear, and let me say at the outset that I don't agree at all with Mr. Raju, and I don't agree on large points of what Mr. Desai has said. And the point I'm making is something which has not been touched by any of the speakers, which is actually integral to this particular issue which we are discussing. And that was there a need for these laws in the first place? Because one is discussing the laws and the other is discussing the need of the laws. But before I do that, just a word for the redoubtable Ram Jethmalani. I would call him the miracle of creation. He had attributes which are absolutely extraordinary. And with a mind it was razor sharp and a tongue which could not be more blunt. And in this circumstance, question is, rhetorically speaking, how would Mr. Ram Jethmalani have reacted to this particular comment? Because Mr. Amit Shah had referred to it, that this is a Swadeshi system now, and we have got rid of the colonial baggage. I personally feel that Mr. Jethmalani, considering as he did the entire life, the span of his career, where he imbued law with distinctively Indian jurisprudence and helped it grow, recognized as the finest mind in criminal law, could not but have felt offended at this particular description. Why I say so? Because the assumption is, and I'll deal with what Mr. Raju and Mr. Desai and what Aishwarya has also said, the assumption is that the law was fixed, stagnant, or stuck, or that it was archaic, it was obsolete, and it was antiquated. And nothing could be further from the truth. Because what is very relevant are the principles. And what is important to note is that the law as it existed was premised on sound principles, was adaptable to advancing knowledge, and was kept in pace with the developments of society. And I'll elaborate upon this later. Now, it may have originated with the British, the English. However, it was modified to suit our circumstances. It was blended with Indian jurisprudence to actually eventually spread. This is something no one has actually touched in this panel, spread across several jurisdictions. These codes have spread across jurisdictions, and which itself is a testimony to the wisdom from which they have actually originated. Now, this brings us to the issue as to why. Why were these three codes at all brought in? And that is the historical context to it. Again, it's not been touched, but I'll just briefly refer to it. Because notwithstanding the cultural unity of India, and the fact that the idea of India has always been present, the state of laws at the time these codes came into being was in a total disarray, because there were various legal systems and there were various legal principles. Because there were various legal principles and legal systems, there's a necessity for a code. And there's a difference between the code, that is the Benthamite approach, and the common law where Blackstone is actually concerned with it. And so the codification of law addressed the want of coherence and proportionality in the laws as they existed, and tried to also address substitution of a judge as a legislator, because you have to have a legislature not as a judge, and prevent adventitious, summary, random outcomes. So once you have provisions which actually set out and define what the law is, and you've got the method to actually apply it, the element of arbitrariness goes down. And that is what brings the code in. That is the need of these particular codes. And the need which was the basis of these codes coming still remains current, which I will just show. And the fundamental principles on which they're based have not been changed. So in this particular description that now we have a Swadeshi system is missing the point altogether. It was distinctly Indian. It was fully Desi, even at the time of its being replaced. And therefore, this description is, in my opinion, more a question of bringing in semantics rather than substance in this particular debate. Now, I will begin with the Evidence Act. I will begin with the evidence because I'll deal with each of the laws. And why will I deal with the Evidence Act? Because it's got the least number of changes which have been brought about. Now, what is the purpose of the Evidence Act? The purpose of the Evidence Act, dealing as it does the adversarial system of adjudication, is to facilitate reaching a just or reasonable decision. That is the whole purpose. And the quality of the process depends upon the principles of evidence. What is the principle of Evidence Act as originally enacted? Premise law. The principle of evidence on the Evidence Act originally enacted was premised upon certain cardinal principles, which was 1, insistence on best evidence; 2, the importance of relevance and admissibility; and 3, the discretion in reaching a particular outcome. Now, if you look at, none of the panelists have actually dealt in detail with the Evidence Act at all. And I think we should actually start with the Evidence Act first. Now, as far as these aspects are concerned, Mahesh is there. I don't think his knowledge of law is supreme. As far as these aspects are concerned, there's no change. No change on the cardinal principles of the Evidence Act. And the biggest tribute you can give to the Evidence Act is the absence of change in the substituted code. That is the biggest tribute. Now, if you are giving a tribute to something which is described as colonial, how can you keep it Swadeshi? It doesn't make any sense to me, because that is, in fact, which is a contradiction in terms. And what is actually missed is that Stephens, who made the Evidence Act, that is, the Evidence Act is made for India. When he went back, he was told to draft another Evidence Act for the English. That means that was the level at which this particular Evidence Act actually stayed, because it was codification of principles which are actually by Mr. Raju, by Mr. Desai, and by Aishwarya about electronic evidence. It's nothing new. Electronic evidence came in the year 2000. We got the Act, amendments are made in the Evidence Act, amendments are made in the Code of Criminal Procedure. Those particular things are there. It's not that something novel has come up, or electronic evidence has come for the first time. Electronic evidence has been there for the past 24 years. Now, as far as that aspect is concerned, we leave that aside. But the point is, there were no major changes in the Evidence Act, except, and this is pertinent, to respond to the addition of offences, which I will deal with when I deal with the IPC, wherein to facilitate conviction, there were changes made in the Evidence Act. We brought in 113A, 113B, and other provisions. So broadly, it was intact. But what have the changes now been made? The changes that have been made are changed the marginal notes. That is, the headings of the sections. Now, it's absolutely not much, because it's in the body in any case. The changes is basically cosmetic. Changes have been made in illustrations. And the changing illustrations are not changing the illustrations. It is changing the illustrations for purposes of accounting for inflation. That is, where it was 100 rupees, it increased to 1,000, 1 lakh. But even that has not been done. It has not been done across. But the biggest change, in my opinion, something that has not been flagged or marked, is the change in the definition of secondary evidence. And I personally feel that that is not a change which is positive, nor is it a change which, in my opinion, will do good in the long run, because the definition of secondary evidence as it stood originally, in my opinion, was a better drafted definition with greater clarity in use than the substituted version of it. But be that as it may, these are broadly the changes that are there in the Evidence Act, the most crucial act for the purposes of adjudication, because as I began, it is for the principle of evidence that the adjudicatory process comes, and the fairness of adjudicatory process is integral to due process. As far as this act is concerned, as for the substituted act, the changes are more in the mistakes than in the improvements. Which brings me now to the Code of Criminal Procedure. Now, the Code of Criminal Procedure, this description of colonial cannot possibly apply, and I'm surprised no one has actually dealt with it. Please see the year of the code. The year of the code is 1973. That is, it is a product of Indian genius. And then what is it? How is it 1973? Did it come from the heavens in 1973? It has got a history to it. The changes, a few amendments made to it after the last decade of the previous century, before we got independence, but the changes began from 1955 onwards. And then the major change came through the 41st Law Commission report, which started in 69, continued to 72, and then was deliberated for 4 years. Now, this deliberation of 4 years will become very important. The joint parliamentary deliberation. And when you contrast it, the deliberation of these laws later, because I think it was a couple of months, and 2 days were given to the parliamentarians for the purposes of examining it. And it was said that 2 days is adequate for a code as exhaustive as this, which covers the entire spectrum of criminal law, with which I have, in any case, I have an issue. But be that as it may, now, the first thing which you say is, what did the Code of 1973 do, which is replaced? It said what basically did, guaranteed fair trial. That is, the principle of fair trial is embedded in it. And I'll deal with what Mr. Raju said in a minute. First, 2, it provided simplicity in procedure, which continues. 3, it dealt with delays, which is, in any case, an ongoing process. It's not as if we have to substitute a code, alter it altogether, give it a new name, juggle the sections, and then bring a new law. But because this is a process that's there, could have been addressed through amendments, if at all. And most importantly, apart from other various changes that took place in the other case, the separation of the executive and from in the dispensation justice, the executive magistracy from the judicial magistrate. These are the changes which was made. Now, this was a very progressive code. A progressive code dealing with bringing in new types of trials, dealing with particular kind of offences, altering particular methods, expediting the process and dealing away with the committal proceedings, etc., an overhaul of the system. But point is 1973. post 1955, pursuant to Law Commission recommendation. There were at least three which are prominent. I think the 14th, 37th, and the 41st, which is there. These are the three law commissions, Indian law commissions. It's not as if the law commission was constituted at the time of the Penal Code, Indian Penal Code, which was made. Now, so this description will not in any way avail. But now let's look at the changes which have been made in it. One, I feel it's got a rhetorical flourish to it. Mr. Raju referred to it. How about the timelines? And I'll deal with both when I have some difference opinion, both Mr. Raju and Mr. Amit Desai, where this is concerned. Now, as far as the timelines are concerned, it is all good to say there will be a timeline. But the point is, for a timeline to be effective, there has to be infrastructure. Now, everyone knows that as far as the legal system is concerned, the judge population ratio is really very low. There have been various recommendations to improve the judge population ratio. Now, that is one of the reasons for the pendency. Now, you can have a timeline, but you don't have adequate judges, you don't have proper infrastructure, and you've got a system working at the lowest level of its efficiency. When you have this system, what will the timelines do? The timelines cannot do anything. So this becomes the talking point. Yes, it makes a very nice political statement. So we have got now a system where we are guaranteed this particular thing and the gullible will be taken in. Oh, yes, this is very nice. But the point is, will there be any result on the ground? The answer is an emphatic no. There will not be. But be that as it may, Mr. Desai mentioned something. He said, he didn't talk about the timelines in this context. He said, penalize. Penalize those who don't do it. Now, where is substantive due process to come over there? Now you'll penalize the cops for not following the timelines. You'll penalize the judges for not framing the charges. Where will the poor accused go? Everyone will avoid the penalty. The police will avoid the penalty for the timeline. The judges will avoid the penalty where the charges are concerned. So you'll have cases being filed and charges being framed without any reference to the law. Is that due process? That can't possibly be due process. And there's no reason why you can actually justify this particular exercise. Firstly. Secondly, Mr. Raju mentioned the fact of sanction and talked about they'll be deemed, as far as is concerned, the question of deemed sanction, inappropriate. It is wholly inappropriate to penal jurisprudence. I would not in any way, I would not consider it as a positive measure at all in this particular exercise. But of course, there's a difference of opinion. But the point is, you don't need to overhaul the code for bringing these changes about. In any case, these are not changes which are that fundamental as far as the basic structure is concerned for there to be an overhaul in this particular issue. Then comes the third, the question of remand. Both Mr. Jethmalani, Mr. Mahesh Jethmalani, and Mr. Desai had dealt with this particular issue, various aspects of it. There much to be said at both points. But what I am basically going to flag is not what Avuthadan said. I am going to flag the issue of the wording of the section, and that is where it's very important. That how do you express what you have to say, and that is where there's a big problem in each of the statutes. As far as the wording is concerned, the wording lacks precision. Because the wording lacks precision, it is open to multiple interpretations. Because it is open to multiple interpretations, it will be lost in a legal debate. And something that basic as this should be clear and of easy understanding, not to be lost in debate. It makes a nice courtroom drama, but it actually mutilates the rights and denies defenses. So as far as that aspect is concerned, not touched, but this is an aspect which is in fact the problem across. Which brings me to the issue of preliminary inquiry. Now, why is the question of preliminary inquiry? Mr. Raju said, see, there's a question of you can file FIRs electronically and there are zero FIRs, etc. over there. The question is, where will the FIRs be? If there's a preliminary inquiry, and as the preliminary inquiry is concerned for a class of offences which affect the common man the most, up to 3 years. Now, as far as the common man is concerned, he'll be at the mercy of the policeman. Mercy of the policeman, why? Because there will be a preliminary inquiry. Why should there be a preliminary inquiry? What will the preliminary inquiry entail? You're inverting the principles of criminal jurisprudence by having preliminary inquiry, which is over there, which is absolutely, it's more or less like what Mr. Raju had said about the question of cognizance, that you're the accused will have to say, what you are doing is you're jumbling up criminal procedure. You're jumbling up criminal procedure without adequate forethought, without looking at the consequences. You are playing with principles which have been settled. You are interfering with processes which are no longer in dispute. You are introducing concepts which will only create confusion. And while this becomes very important for a person to make political points, as far as the working system is concerned, the working system is hampered irreparably. because it's hampered irreparably. It defeats the very purpose of bringing a code. Why do you bring a code? The purpose of codification is clarity. The purpose of codification is precision. The purpose of codification is uniformity. Now, all the purposes of codification are lost by the way in which this particular exercise is actually undertaken. This whole process, the way in which it's undertaken. But that said, there are the three aspects which Mr. Desai had pointed out. One, he talked about the retributive aspect, and he was critical, as most people are, retributive aspect. So actually, I don't share that opinion. About as long as death is there, I don't see as such, this is one of known punishments. The principles of law are very well settled when death is not to be there. But the reason for the Supreme Court to revisit punishments was that there was a big gap between death and the other offenses. Because there's a big gap between death and other offenses, you have specifically have certain offenses for the remainder of a person's life. That will not in any way impact the constitutional power which is there for the purpose of dealing with these particular things. But that is a question of debate as to what the sentencing should be. Now, as far as the issue of sentencing aspect is concerned, that required, in my opinion, and that's the reason why the pre-legislative exercise had to be more elaborate than what was actually undertaken in this particular case, to examine the nitty-gritty of these particular aspects. It's easy to discuss superficially these matters through an exchange between lawyers here in over a period of 15 or 20-minute period. But that doesn't do justice to that particular controversy. It requires a detailed deliberation, because it is not emotions which come to play over here. It is the law. And as far as while sentiment has got a very important place to play in law, as far as law is concerned, the law should not be in any way captive to sentiment alone. Because the law is captive to sentiment, it lose its worth altogether. But anyway, coming back, one was as far as what Mr. Desai said, it's the retributive aspect. Two, the delay I've already dealt with. It affects the substantive due process, because there'll be expedition. You are going to more or less bulldoze justice onto people, which is not in any way. Number three, we can't keep talking, because he said in remand, you should have the provisions which are clear. The provisions which are clear. Now, as far as remand is concerned, the law is clear. As to when a remand has to take place, the circumstances have to be there for the purposes of remand. And we have to get rid of this habit now, and we are full of this habit in this country. Put everything in writing. Everything cannot ever be put into writing. There'll always be something which will be incomplete. Point is, you have to develop a constitutional ethos. We have to approach it in a manner which behoves our constitutional principles. When the principles are in place, whatever the statute imperfections of language may be, the imperfections of language have to be dealt with the settled interpretations of law. And when the deficiencies are dealt with that particular aspect, that will address the issue altogether. So as far as the issues are highlighted, Mr. Desai, that this was not there and that is not there. Yes, ideally it should have been. But the want of it at this point of time will not in any way avail, because the law, and that's what I'm saying, that goes again to whatever I repeat, law is clear, the Supreme Court has intervened, guidelines were in place. It's not as if that we were going blind, which is there. And on this particular issue. And even in whatever the substitute of 436A is, I think 479, Mr. Desai's objection regard to one of the subsections, in my opinion, is misconceived. And I don't share his ideas in trial of absentia. The problem with trial and absentia is the manner in which the provisions have been worded, which should require a more detailed discussion as far as the lawyers are concerned, but not necessarily relevant for this particular discussion. The point being that there being no major shift and the principles being more or less intact, a few changes here or there will not in any way make much difference to warrant a recodification of this particular exercise. Which brings me to the penal code. Now, as far as the penal code is concerned, what is very important is that the penal code as was drafted, and this is actually the law, penal code was drafted, was superior to English law. It was free of all its superfluities and ambiguities and technicalities. That's the beauty of the Indian Penal Code. It was better than the English law. One. Two, what happened insofar as the Penal Code is concerned, as I said in the beginning, it was a Benthamite response to the common law system and entailed rationalization of the law. Because there's rationalization of the law, there was vast swathes of area where Muslim law was in place, where Muslim law had its own inadequacies. There's a problem in the interrelationship between Muslim law and Hindu law. Besides, there were some laws in the presidency, there's some laws in the mufassils. There was complete chaos which was over there. So there had to be some element of clarity. We brought in this particular code. So it was for the purposes of application in India. This is number two. Number three, the entire history. Look at the history of the penal code. It has remained substantially intact. It has actually remained substantially intact. There's been actually no. The changes that have been there are, one, through courts, which say, okay, some provisions are ultra-virus because they offend the societal norms. Some provisions are ultra-virus because they offend the constitutional principles. That means to the extent intervention was required, intervention did take place. A related aspect, the legislature was alive. Societal concerns, there were social issues. Social issues have to be dealt with. You had new offenses which were incorporated. So those offenses were added. So the removal of the offenses and the addition of the offenses show that the law is alive, that as the law is adapting, that the law is growing, that the law is attuned to the needs of the society. And the law is adapting, growing, attuned to the needs of society. Is it alien? Is it Videshi? No. It's neither alien nor Videshi. It's fully Indian. It's got the Indian genius embedded in it. It's got the Indian genius creating it. It's got the Indian genius evolving it. You cannot possibly condemn it. Condemn it as something which is a colonial construct because it's not a colonial construct, which brings me to the other aspect. How many? As many as I think there would be 19 law commission reports. About 19 law commission reports would be dealing with the Indian Penal Code. The 42nd was the most comprehensive. It led to the 78 bill. 78 bill was considered by the 156 law commission. It made various changes in it. So these are the law commission reports which are there. And the law commission reports examined it. When the law commission reports examined it, that is the whole process in which it is being undertaken. Certain suggestions are made and certain were not. And very interestingly, though this government is defensive, I am a votary of sedition. I have the defense of sedition. I have been uncompromising in saying that yes, there should be nothing wrong in the inclusion of sedition in the penal code. The government has backtracked. The government is defensive where that is concerned. But what the government has missed is that even where the sedition is concerned, the reports of the Law Commission suggested a more elaborate provision for dealing with it. And acknowledge the fact that the sedition as it avails in the Indian system is not what was there at the time of the freedom struggle. It's an improvement of it. This is basically what Kedarnath has actually dealt with. And insofar as the understanding is concerned, not mere disaffection, but a tendency or intention to create disorder. That was the basic test which is over there. And the Law Commission actually said you add it. But you make improvements on it. So why is the government defensive? Now, as in the existing scenario, in my opinion, no offense is more important to be on the statute book as sedition. Be open about it. We think sedition is necessary. We will defend it. You may disagree with us, but we are not going to shift position from it. The fact that you are defensive means you are not clear to your own position. And that's the reason why when I come to the definition which has come now in the penal code is basically attempted to compromise. You want something, but you don't want to say you want that. So you have something substituted, and then you say in it things do not make complete clarity or sense and render yourself vulnerable to criticism. This is what has happened over here.
But Mahesh Jethmalani is better equipped to sum this up. I would only say that I have enjoyed your arguments, both for and against, of all our panelists so far. And Mr. Jethmalani is best equipped to summarize and respond to the points of our last two speakers. And then we'll have closing remarks. Mr. Jethmalani.
Thank you, Arnab. Thank you so much, first of all, for, as usual, extending your generosity and giving us this, platform with its great reach.
Please.
For the Ram Jethmalani Memorial Series. I mean, it's invaluable that you've given us, and so also NewsX. But they're also going to be broadcasting this live tomorrow. So thanks to them as well. Look, there have been very, very important points raised.
Yes.
I myself did not detect some of the, and although I've, given a number of lectures and spoken in Parliament as well about these laws, I myself have not detected some of the flaws that were pointed out today. Both Mr. Raju and Aishwarya Bhati have rendered, they're invaluable assets to the government, and they've proved it today on the show. Aman Lekhi is Aman Lekhi. He's, one of the most trenchant critiques of every assignment he's given. He brings his, incisiveness and shows up the flaws in the law. As does Amit Desai, a proficient practitioner, cerebral person in the extreme. If you read his articles, you will find out that he's really analyzed these three laws very well, and we must take his criticism seriously and see how best we can improve these statutes. Just a word, since we're running out of time. These three statutes are a break from the colonial past. And I'll just give you three examples and leave it at that. Aman has made a point, and I respect that point of view. But let me tell you, just give you three examples. And that probably will tell you why this is a break from the colonial era. Let's start with the sedition law. The sedition law has been stayed by the Supreme Court. Why was it stayed by the Supreme Court? Because it was being misused. Why was it being misused? Because the government of the day, right, used to prosecute critics of it on the ground that the section itself said that you can an offense of sedition consists of inciting disaffection against the government of the day. Now, those words were verbiage used by a colonial government to protect itself from its colonial subjects. When you talked about inciting disaffection against the government of the day, you were talking about the colonial masters. Sedition therefore became a bad word and it was stayed. It was being misused. You criticized the government of the day and sedition was invoked. Ultimately, it was stayed. So, Aman is wrong to the extent that we should have made a resounding defense. We couldn't make a resounding defense because, in fact, the sedition offense resounded in colonialism. What we did was, the government changed, got rid of the old baggage, including the use of the word sedition. Instead, it said anybody who threatens the sovereignty and integrity of India. Therefore, it's intended to punish subversives, people, secessionists, separatists. Those are the kind of people whom the Act now, contrary to the colonial masters who are trying to protect themselves, we are now talking about the Indian state and not the government of the day. The offense is directed against the Punus, against all subversive abroad. It's against ISI. It's against anybody who tries to undermine the integrity and sovereignty of the state as opposed to the government of the day. That cures that takes care of the reason why the Supreme Court stayed it. Because it was being misused, you could not criticize the government of the day. I'll give you another example. Abetting murder. Very quickly, Arnab, to give you why this is a break from the colonial past. Right? Now, this is abetment. The offense of abetment had this illustration. Right? A in India instigates B, a foreigner in Goa, to commit a murder in Goa. A is guilty of abetting murder. The illustration to the section indicated that Goa was not a part of India. It was a foreign country. This illustration had to go. This was a the Indian Penal Code had not recognized that Goa got independence from the Portuguese in 1961. It was legislative neglect of the worst kind that you allowed in your statute book an illustration which did not recognize that Goa had now been incorporated in India. Third, there were words used, right, in many sections. There were words used like insane, colonial words. When talking about people of unsound mind, insane and idiots. The word idiot has actually been used in the Indian Penal Code to describe people of unsound mind. The Sanhita has given up these pejorative, insulting words. It's used the more compassionate phrase, persons of unsound mind. Otherwise, you had words like idiot, insane, lunatic. That was colonial. So, and finally, Arnab, the fines had gone completely obsolete. You had a maximum fine of 500 rupees for serious offences. Today, there are 81 sections whose fines have been increased because the fines were so negligent that they constituted no deterrent at all. They have now fines ranging up to 10,000 rupees for cases like assault and grievous assault. So there was a lot of colonial baggage. I'm just talking about the Sanhita, which replaced the Indian Penal Code. There is so much more to be said for not just the improvement from the 1898 Criminal Procedure Code, but even the 1973 amendments were totally ineffective. And the present Nyaya Suraksha Sanhita introduces far-reaching changes in even the present code from what the Criminal Procedure Code of 1973 had as its provisions. Finally, it's an act of sagacity, Arnab, that the Indian Evidence Act was left largely untouched. The only provisions that Aman rightly pointed out was to introduce electronic evidence and to lay down in the Evidence Act the rules for its admissibility. That had to be done. It was a necessary exercise. It hadn't been done because obviously the colonials didn't have electronic evidence. We had to incorporate that. That's why it was a colonial era law, because it didn't have the technological changes which modern India does. So all these reasons, these were a break from a colonial past, and where the break was not required, the fundamental principles which underpin our entire legal system have very sagaciously been retained.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.